Fundamentally, law is something from which we can use as the basis for civilised dealing in a society without killing each other and as the method of solving problems. But if we don't have a good fundamental law system that applies to everybody, then we may as well not have one at all.
Well, the law is about the protection of individual rights and freedoms. The law is necessary for people to live together so that everybody gets a fair go, and the people who are not prepared to give others a fair go are dealt with by the law. That's the purpose of the law.
From an Indigenous perspective, true purposes of the law, of our law, is to keep order in our society or in our communities.
The purpose of the law has changed over the last century or so, where it's now a matter of Parliament or government having control of the people, which is not the true intent of the law or purpose of the law.
One of the key things about any law is, as Geoffrey Robertson put it, is that it's got to have a system of law which has inherent in it that a citizen can defeat the government if necessary. We now have a system of law in which the citizen can't defeat the government, in which the system has been rigged to ensure that the citizen can't beat the government.
My understanding it started in 1973 when a gentleman, Frank Conningham, was travelling, making one of his many trips between Australia and the UK. He worked in a sort of very official government capacity.
He was travelling on an Australian passport in which the Queen instructed people to give him various assistances, and when he got there he was told, go and get in the aliens queue, you belong over there, and he produced the passport and they said, we don't care what your passport says, you go and belong over there.
All his previous journeys there, when he arrived at Heathrow, he lined up under British subjects and went down that queue through passport control. What happened on this occasion in 1973 was he was put into the alien queue. Despite much protesting, he couldn't do much about it. Unbeknownst to him, the UK Parliament had just passed the Immigration, Asylum and Amendment Act of 1973, which made all Australian citizens no longer British subjects.
When he came back to Australia, and then he is a mathematical physicist of great note, he spoke to a number of his colleagues, including a number of senior QCs. And they said, oh yes, the law is, in fact, the fundamental law is the Constitution. He said, well, what's that in legal terms? And they said, oh, well, it's an English law. He said, well, hang on, how can we be under a law and yet they're telling us we're aliens under that same law? There's something crazy going on here, and he started to dig.
On his return from the UK, he sought legal advice from some of his many friends, and I understand one he went to was Colin Howard, who was the Hearn Professor of Constitutional Law at Melbourne University. After some discussion and research, my understanding is that Colin Howard informed him that, well, the Constitution's not valid. Continuing the research, Frank went and saw the Secretaries of the Treasury and also the Prime Minister's Department. And my understanding, the response he got was, well, it was about, we realised someone eventually would find out. So that they were well aware of the illegal basis of it. They then set about developing further research and also talking to politicians, because at the end of the day they thought that it has to be corrected. The way to correct it is to get a political solution. So they dealt with politicians. My understanding is that during the crisis events of '75, Gough Whitlam, Malcolm Fraser, the Governor-General were aware of this research and this information. Going through the 80s, even it was discussed with Bob Hawke, Paul Keating. It was Keating's suggestion that yes, it should be put in front of the people, and the way to do that was by way of referendum, which was eventually held in 1999.
Now what we did is we decided we'd set out, firstly, just to get the facts out into the public. to say to people, hang on, what is this that you're obeying? What is this law that you're obeying? What's its source, what's its origin, what's its authority, and do you still accept it? Now, the government got the wind of this, and so they ran the Republic debate in November 1999. Most people tend to think that that debate was about the Republic question as whether or not we had an Australian head of state. In fact, the real question was question 2, the so-called preamble question.
The system that was presented to the elector was presented via a booklet called the Yes and No booklet, which set out what was to happen with the referendum, what the referendum question was, and the 2 options, which was the Republican option and what we might call the monarchist option. The monarchist option was, of course, only part of the Constitution, Section 9 only of the original Constitution Act.
The so-called preamble question contains a clause which says, we, the Australian people, commit ourselves to this Constitution. It is the first and only vote ever taken of the entire Australian people about the Constitution by which we're governed. And by 60.66% to 39.34%, the people said no.
So people were told in that booklet if they voted yes, they would be voting for the Republic, and if they voted no, they'd be voting for Section 9 only of the Constitution. So the fact that the no vote got up reinforces the government's position that only Section 9 of the Constitution applies. And I believe in 10 or 20 years' time, that'll be the proposition they'll put to the people, that, you know, Australia voted on it in 1999 and they accepted only Section 9 as being the Constitution, when in fact it's not.
The Constitution that we have in Australia is Clause 9 of a United Kingdom Act passed in July 1900. The first 8 clauses, or the so-called covering clauses, Clause 8 of that describes the Commonwealth as a self-governing colony. And for the purposes of law, that's what it remains. Now, in the 21st century, that's just no longer valid.
Trickle Treaty, Commonwealth power to make and implement treaties. It was a report by the Senate Legal and Constitutional Reference Committee published in November 1995. It says quite clearly that on signing the Treaty of Peace and becoming a member of the International Labour Organisation, we were a sovereign Australia was a sovereign nation from then. It also refers to the Imperial War Conference held in 1917, and it was decided at that meeting, resolution number 9 refers to that come the end of hostilities, they will have a special conference to sort out the constitutional arrangements with the Dominions, because they were saying that they should be treated equally at that point in time. And this is borne out in 1921, in 1926, in 1931, and so on.
And one of the rules of becoming a member of the United Nations is that you must be an independent, sovereign nation. That means you cannot be ruled, regulated or influenced by any other sovereign nation, such as England. What the Australian government should have done on that exact day, within minutes of that documentation being accepted from England, is they should have instituted the replacement legal systems for Australia, and they did no such thing.
In 1998, there was a further development. I think various people in Melbourne realised that the politicians weren't going to give them an adequate forum to have these issues ventilated. So they thought the opportunity would be, okay, we get some cases going, we get them into the High Court, and the politicians aren't prepared to fix it, but the judiciary put it in front of them, them being honest people, we would expect them to fix the problem. at least make the politicians aware they have a major issue legally for the legal basis of law in this country.
The theory is that the courts are independent of government, but I think that's long proven not to be the case.
This is the first time these issues were put before the highest legal body in Australia. The first time the High Court had the opportunity to view these issues. It was by way of an application, a Section 40 lift application from a lower court, and the decision is Jose versus the ASIC, which was handed down, I think, 12th of December. It was dealt with on the 12th of December 1998. And what Justice Haynes said in that meeting was that he had a duty to protect the system. We felt a bit cheated by that because we thought he was there to interpret the law and apply the law correctly. That apparently appeared to be secondary to preserving the system.
I think clearly the Australia Act, in the way that it enacts Australia as a separate nation and separating from England, has logistical and legal problems in that any changes to a constitution requires a referendum in this country. And clearly the Australia Act does change the constitution. In fact, it changes the heads of the constitution, and that was done without a referendum, and on that basis I would think that it was illegal. As an Indigenous Australian, I have a very cynical viewpoint of the Australia Act and why it came about in 1986. When one looks from an international perspective at how the law's gone for Indigenous peoples, you can see that in 1982 the Canadian Indians went to the Privy Council on the issue of treaty rights and the assertion of joint sovereignty. The Privy Council found in their favour, and as a consequence of that particular case, the Canadian government were forced to recognise joint sovereignty, domestic nation status, and in fact constitutionalised it through Section 35 of the Canadian Constitution. The 1986 Australia Act conveniently cut off any connection to that higher authority for Indigenous Australians. So, in my view, there was more to the Australia Act than to give us independence as a country. There's actually three elements of what you need to show legally at sovereignty to be able to claim occupation, which is how this country was claimed. And they are, firstly, terra nullius, which we've all heard about. And the other one is effective control, and the third being a will and intention to act as sovereign peoples.
Captain James Cook, when he arrived to charter the land and waters of the continent of Australia, had instructions, specific instructions from the Imperial Crown and the British Admiralty, only to do things with the consent of the Aboriginal natives of Australia. That was completely ignored.
Terra nullius, basically, at law means land belonging to no one here.
So the basis upon which the occupation, the possession of Australia by Cook was a fallacy. Totally legally wrong under English law and international law at the time.
Even without Mabo overturning terra nullius, I think it was always questionable in international law, that whole issue of occupation and the legal nexuses that go with it.
What we were trying to achieve by going through the Commission on Human Rights and to eventually get to the International Court of Justice was to open the lie, the international lie, that Australia is a country of people, a democratic country that has been through a decolonisation process. And as a result of that decolonisation process, Aboriginal people have also gone through it. And by some magical formula that we don't know, we've consented to the establishment of the Commonwealth of Australia and the states, and that the transfer of our land and territories and water rights were legitimised by some process unbeknownst to us.
The fact is, we have a bureaucracy which has inherited its original powers from the convict days. It hasn't changed its methods from the convict days. It hasn't changed its attitudes from the convict days. They regard themselves as the public masters, not as public servants. So we decided that the way of challenging this would be to challenge not the weakest department of the government, but the strongest. And of course the first thing we found was that there was no such animal. The fact is, nobody had ever actually created the taxation department. The constitutional basis on which our money was taken off us was never done. And in October 1999, before the federal court, we actually proved that it had never been done. Here was something which should have been absolutely fundamental. If you or I set up a new company and didn't register it, or didn't file the right papers, or didn't appoint people the right way, we would be in court and fined. And yet here we have the most influential and important department in the country which had no legal existence. Well, we went into courts. We fought now some 9 High Court cases, numerous cases in other courts, and we sought to apply the very simple standard that if the people had to obey the law, then the taxation officers had to obey the law. And we discovered that the courts were not prepared to make taxation officers obey the law. The courts were not prepared to say, this is not legally done the right way, it must be fixed. The courts allowed the taxation officers to carry on illegally. And in one fell swoop, they demonstrated that the true function of the courts was not justice. It was not all of the separations of powers, etc., which they like to protest is what is their true guide. But they were simply an executive instrument whose job it was to safeguard the revenue and the money coming in to pay their own salaries.
The courts are an instrument of government. They're set up in the Constitution as an instrument of government, although they're supposed to be independent. How can you have an independent court, say an independent High Court, when the politicians, in particular the Prime Minister, appoints the judges? How can they be seen to be independent?
If an entity is not a legal entity, is that not one and the same as saying that it is an illegal entity? To which the Australian Federal Police, on a transcript tape, which we will be making available shortly on our website, said yes, that is correct. But I think from memory it is the 1899 Crimes Act, currently represented as the 1914 Crimes Act, that actually stipulates that if you interact with, pay or encourage a known illegal entity, it is a 7-year jailable offence. And here we have on the website a document stating that the entire Australian Taxation Office is illegal.
The Constitution, under Section 51, gives the government the right to make laws for peace, order and good government. Yet in the Ryan case, in the High Court about 2 years ago, the High Court ruled that we were not entitled to fair and just tax laws. And that's the statement of the Chief Justice of the High Court. Now, if fair and just tax laws are not laws for peace, order and good government, what are? And what people seem to forget is that just about every major revolution in history started on the basis of unjust taxation.
Taxation that is based on transactions, whether it's debits or credits or whatever, if it's based on all transactions, without exception, without any exclusion, everybody pays an equal amount of tax. So the people that are avoiding tax to a larger degree, the mega corporations, all those people would have to pay their fair share of tax. And that's not happening at the moment. Mums and dads pay all the tax.
When our tax system was first set up, we had a system which taxed most of the business in this country. Today, most of the businesses in the country is done by overseas-owned companies, who in turn pay their taxes overseas, but not in Australia. The result is that you've got to collect more and more tax from the ordinary taxpayer, from the small man, from the ordinary punter in the streets. And that, of course, gets more and more unfair.